6,000 people protect the assets that they leave to their loved ones from creditors, divorce, and lawsuits. We've also helped over 300 families implement the plans that we've designed to make sure that when they go to the next level, so when they go to your loved ones, that the plans actually work. Because what happens with a lot of estate plans when you put them together, it's kind of a depressing topic. So we're talking about who gets your stuff when you die. So once we've had that conversation, a lot of times your temptation is going to be to put the originals in a safe deposit box or in a fireproof safe, put the copies up on a shelf and totally forget about it. But what you really want to know is that those documents work on the back end. So if you become incapacitated or you pass away, things happen the way you want them to happen. And so one of the advantages to having an attorney or a law office that's actually implemented these plans is we know for sure that they do work on the back end. Our firm does estate planning and it also does elder law. Estate planning is the who gets your stuff when you die, which is what we're going to mainly talk about today. Elder law is if somebody needs to go into skilled nursing, how we pay for nursing home care or pay for long-term care through both Medicaid and veterans. And I'll touch on that just slightly today. I'm a member of Wealth Council, which is a group of about 3,000 attorneys nationwide, and we collaborate on both trusts and wills to make sure, like I said, that they work on the back end. So you're not only getting the experience of our firm and the attorneys that work for our firm, but you're also getting the experience of the other attorneys that belong to the organization and the things that they've seen go wrong and have fixed in the documents that are there. NALA is the National Academy of Elder Law Attorneys. We collaborate on both Medicaid and veterans benefits. All the attorneys that work for my office are personally chosen by me and trained by me. I've just recently written a book. It's the Who Gets Your Stuff When You Die. It's the speech that you're going to hear today. But whenever I gave that to my publisher, he said, you have about an eighth of a book. And so I had to add a whole lot more stories, a whole lot more examples. It's been about 6 months since I had it published. I've already got ideas to pretty much double the content because of the number of questions people have asked based on what we're doing related to the speech. Some of you got the flyers we sent out. Some of the people saw it on Facebook. We had an amazing response from these flyers. Something I'll definitely do again. We have about 150 people coming to seminars just as a result of those flyers. So there's a lot of need out there for education. What I try to do with these seminars is just educate you, give you information so that you know what to look for, what you're wanting in documents, and it just kind of helps you think. So ground rules real quick. Phones, if you can turn them off, that would be great. Other thing is if you could hold the questions till the end, because a lot of times when you raise your hand and you ask a question, it may have to do with something that I'm just getting ready to cover on the next slide or further in. I was just at a seminar where we had 2 people that spent the whole seminar asking questions that the majority of the room didn't want to hear the answers to the questions. And so it really kind of delayed the seminar. So that way I can definitely get the content that I want to and make sure that you guys get the information that I'm wanting to give you. As far as your folders, on the left-hand side, there's a questionnaire. If you guys fill that out, all I'm going to do is invite you to seminars just like this. So if you want information for seminars just like this, you can let me know and we'll send information. And if you know anybody else that would benefit from a seminar like this, I would love for you to pass on the information. So I'm going to talk to you guys briefly about who gets your stuff when you die. 14 secrets to protecting the 2 most important things in your life: everyone you love and everything you own. I had a business coach to figure out who your favorite client is. And I want you to pick out 4 or 5 people that you just love working with by name, and then I want you to write down what the criteria is for those people, like who are they, how much money do they have, what's their family situation. And what I discovered is I love to work with people that love people, because a lot of the people that were in the list had very little in common other than that they love people. I work with a lot of grandparents that care a lot about their kids and their grandkids, and that's one of my categories of favorite people to work with. I also have a lot of women who have never been married, never had kids, but they do a lot for the community. So they love people. They enjoy being around people. Distributing your stuff. Choosing your stuff and helping them keep it. One of the things that I'll do if you come into our office is ask you a lot of really kind of nosy questions about your family. I'm going to ask you introductory questions. What do they do for a living? Are they responsible with money? I'm also going to ask you the same questions about their spouse. But really what I'm exploring is, if you leave them money, can they handle it? Are there people in their lives that will make them make bad decisions related to that money? Or is there something else I need to know? The really important things when you work with an attorney is to make sure you tell them about your real family. So if I see you at church and I ask you how the kids are doing, they're great. We're great. Kids are great. Everything's great. Nothing's going wrong in my life at all. I'm not going to talk about the things that are. But when we're doing a plan, we actually need to know what's actually going on. I had a lady come into me many years ago, and she told me about her fairy tale son. And her fairy tale son, she hadn't seen in 15 years. And they had a horrible relationship. And she appointed him to be in charge of her financial matters and her medical matters. And then she gets dementia. So she becomes incompetent. She needs somebody to make decisions for her. And this son she hasn't seen in 15 years suddenly steps on the scene and starts helping her. And he actually, as far as I can tell, he actually was at that point being a good son and doing the right thing. But she didn't trust him. And she had lots of really good friends that she could have appointed to make financial and medical decisions for her. But because she was embarrassed and didn't want to tell me that she didn't have a good relationship with her, she didn't tell me the truth. And the hard thing with that is, and I always talk to people about, I don't gossip about my clients. I'm not going to go home and say, I can't believe this woman hasn't talked to her son in 15 years. Actually, honestly, most of my clients have something like that in their family. Very rarely do you run into a family that everything's beautiful and there's nothing wrong. And so we need to make sure that we design the documents based on the actual people that are involved. The other thing to think about is, even if the person you're leaving money with is really responsible with the money they have, are they going to be responsible with the money you're leaving them? 80% of people that win $1 million or more in the lottery are more broke a year later. Yes. And the reason why is, when you ask somebody if they win the lottery, what are they going to do? Their first answer is, I'm going to quit my job. Second answer is, I'm going to spend every dime in the $1 million and more, and then I'm going to be broke and unemployed. But they don't think through, they don't think they're broken through and unemployed. That's not part of their answer, but I'm going to quit my job and spend every dime in the $1 million. So no matter what money you leave somebody, most inheritances are treated exactly like lottery winnings. So most people that have money drop in their lap, they're likely to spend it within a year. And it doesn't matter how much it is or how little it is, they tend to spend it within a short period of time. So think through, when you're leaving people money, are they going to be able to handle it responsibly? Handle with care is what to do if a beneficiary is disabled. If you're leaving money to anybody, most government benefits that are need-based, they're not allowed to have more than $2,000 in their name. So you have a grandchild who was disabled from birth, and he is on a waiting list for a group home. So when he turns 18, he can move into a group home. The waiting list for that is 16 years. So the parents of those children need to get on the list immediately, even though they don't know if they want to be in a group home. But if that child has more than $2,000 in his name, what happens is he gets thrown off the waiting list, and then he has to go back on. So you can make a huge difference, a huge bad difference, for somebody who's disabled. And the law says, because the government doesn't want to pay for people that have money, if you inherit money, you can't say, no thank you, I don't need it, and still stay on the government benefits. So I have lots of situations where, as soon as that grandchild's born, the grandparents start saving for college for all the grandkids. And then that child is diagnosed maybe 7 or 8 years old with some sort of disability. At that point, there's already about $10,000 in the account. Well, that's enough money if that child has that, but it ends up disqualifying them. And a lot of people put them in something called a Uniform Transfer to Minors Act account. So it's an account once you turn 21 you have access to. That's going to throw them off of benefits, so we need to be careful. The other thing that I do in all my plans is I do a standby special needs trust, because we don't know whether somebody is going to become disabled in the future. So even though when we look at your family, there's nobody that's disabled, we don't need to do a plan related to that, we don't know for sure if on the date of your death, if there's going to be somebody who's disabled. So we put that in there just in case. Stuff happens. Smart moves if you or your spouse are diagnosed with Alzheimer's or dementia, or anything where you think you might lose your ability to make your own decisions. What happens a lot in my office is people will come in 8 years after being diagnosed with Alzheimer's. And at the point where they finally come in and they finally realize they need to change their plan, they can't remember how to spell their own name. They can't remember their kids' names. They don't know enough to be able, at that stage, they don't have enough capacity to be able to make decisions. It's much better if when you're first diagnosed you come in, we can make a lot of plans and protect a lot of things. And one of the things that's really important to realize, and this does happen more than we would like, sometimes the healthy spouse dies first, so people die out of order. So there's a wife taking care of a husband with Alzheimer's, she gets exhausted from taking care of the husband with Alzheimer's and ends up dying first. If that happens, if you have a traditional I love you will, and a traditional I love you will, husband leaves everything to wife and wife leaves everything to husband, and whoever survives is in charge. Well, if the healthier one dies first, then the one with Alzheimer's is left in charge of the money. Not a good idea. So we can change the plan where we make sure that if the healthier spouse or the non-Alzheimer's spouse dies first, that the one with Alzheimer's has somebody else to protect their money, somebody else to take care of them, to make sure that they're not in charge of their own money. We can also set it up where it's protected for government benefits. So if the one with Alzheimer's, because their spouse dies, ends up having to go into a nursing home, they can actually have that money be protected. So that money does not have to be spent prior to the nursing home. And then, I was just trying to see if I needed to pause or not. What else I want to tell you about that? Oh, the other thing that occasionally we can do with a diagnosis like that, if we know ahead of time, one of the things I do for Medicaid planning is we can actually do 5-year planning. So 5 years before you need to go to the nursing home, if we transfer money out of your name, we can actually protect all of that money for Medicaid purposes. So if we have a diagnosis like that, it may be a warning sign that we need to start trying to protect money for Medicaid purposes, just in case somebody has to go to the nursing home in the future. One of the things I do, if you have somebody in your family that's not quite ready to talk about the fact that they're starting to lose capacity, we can also talk about it the way I have my plan set up. I have a trust set up. My husband and I both are in charge. Neither one of us ever plan on becoming incompetent. But in the event we do, we've got it where whoever is still competent takes over and manages things. We've also picked trustworthy people in our lives to take over if we both become incompetent. So that way you've got it in place already, it's already there, and we're not having to have the hard conversation based on your actual health going on. As far as planning, the earlier you can plan, the better, because whenever we know you're dying or know you're getting ready to become incompetent, it's a little bit harder conversation. If we can put things in place ahead of time, it makes it a lot smoother. Same with, especially with incapacity. So incapacity stuff, if you're out of it, like I said, the lady who told me about her son and didn't tell me the full truth, think through who you can trust with your finances. And you need to find somebody who's not only good with their own money, but can handle the amount of money you have, and would also be focused on you. Unfortunately, I can tell you several stories of grandchildren I've had come in that say, Grandma doesn't remember who anybody is, so we don't really need to put her in that nice of a nursing home because she doesn't even know where she is. And my philosophy is Grandma's money should be Grandma's money until Grandma passes away. That should be the primary focus. But think through, are you putting people in charge that might not do the right thing? I have a distant relative, since we're actually taping, I'm just going to say a distant relative who got put in charge of a lot of money on behalf of his other grandparents' estate. And he decided that he was going to buy silver. It was back when silver was going way up. And so he bought silver right before it crashed. And he bought silver with all of the money that he was in charge of in his grandparents' estate, plus his own money. So he actually lost all of the grandparents' money and all of his own money. So his cousins had the right to sue him. But he didn't have anything to get in a lawsuit because he lost everything that who is in charge of. So be careful who you put in charge to make sure that they wouldn't make bad decisions. Now, the legislature just passed a law. There's a power of attorney that's now mandatory for people to take with 16 exceptions. And pretty much if somebody doesn't want to take your power of attorney, they're going to be able to fit in the 16 exceptions. There's one that was specifically written for title companies. It doesn't say title companies don't have to take them, which is what you need when you sell your house. But it says that anybody who's not required to do business with you is not required to take the power of attorney, and a title company is not required to do business with you. So even though they say that the power of attorney is mandatory to take, most of the situations where you're going to need to try to use a power of attorney, you're going to have trouble using it just like we always have. It's much easier if you put your assets into a trust and you give the bank or the institution a copy of that trust. And then that way they can, ahead of time, they are bound by the terms of the trust, and they're bound to follow the instructions of whoever you've named next to be in charge. Healthcare stuff. Who makes healthcare decisions if you can't? I had a lady come in to me many years ago. She said, my best friend is in the hospital unconscious. The doctors and nurses won't tell me what's going on with her. Her no-good son has come in from out of town. And to tell you guys, there's some no-good daughters out there too. Just my stories happen to have no-good sons from me. So, no-good son comes in from out of town, starting to make healthcare decisions for her. I know for sure that's not what she'd want. And she was wanting me to go to court and get her appointed to make her friends' healthcare decisions. And the sad thing, at that stage, there was nothing we could do. If her friend had come in prior to going to the hospital and had appointed her to be healthcare power of attorney, we could have made it where she made the decisions. The other real important thing in making your decisions, just in case you have a few of those people in your family that you think wouldn't do the right thing, you can actually say in no event can this person or this person make healthcare or financial decisions. You can name them by name and disqualify them from taking over your assets. I have people all the time that will tell me, I haven't seen that daughter in years and years. She never comes around. She doesn't even call me on my birthday. There's no way she's going to get involved. For some reason, that daughter is the one that gets involved when you become incompetent. She is the one that you haven't seen in forever, tends to be the one that suddenly wants to be in charge of your money, suddenly wants to be in charge of your care. Good stuff. Privacy laws. Under the privacy laws, doctors and hospitals can pay huge fines or go to jail if they release your medical information without permission. So because of that, all the doctors, all the hospitals have hired attorneys to draft HIPAA or privacy disclosures. So when you go to the doctor, you sign that you've read the disclosures. Do you guys ever read them?
Sometimes I do.
Yeah. They actually say you could actually authorize them to sell all your information. I mean, it really is, it's worded, it can be worded really broadly. I don't know if anybody's brave enough to do that in there. But they have to say who they can release it to and under what circumstances with it. And so it's worth looking at, making sure there's no standard form to it. But because there's no standard form, what I do is I give you a HIPAA authorization that authorizes the people you want to look at your medical records to be able to do it. I also add language to your healthcare power of attorney and your financial power of attorney that allow them to sign whatever would make the doctor comfortable. So that way they're comfortable in releasing your medical information. The other thing that I do is if you have a trust, you name somebody else to be in charge of your finances if you're unable to, but what if that person becomes incompetent? So it's a point where they step in and they're actually in charge of your assets. How does the next in line step in if that person becomes incompetent? So I allow the next in line to look at the medical records of the one that stepped in and started acting on your behalf. So that way you're protected if that person does become incompetent. Who needs benefits? This is actually something I give an hour-and-a-half seminar on. So like I said, if you'll fill out the questionnaires, I can send you notices on seminars. We're doing a lot of them around Thanksgiving. Specifically on Medicaid and on veterans benefits. I'm just going to give you guys kind of a really high-level view because I want you to just at least be able to recognize issues related to it. And by the way, the reason why we do it at Thanksgiving, we put a flyer in the paper at Thanksgiving on it. And the reason why is a lot of times people will think that mom and dad are doing fine until they come home for Thanksgiving. Because over the phone, a lot of times people who are becoming incompetent can kind of bluff. And even if they think you're 20 years old and even though you're 50, over the phone that's not going to come out. So a lot of times when people come home for Thanksgiving and for Christmas, that's when they first realize that mom and dad need more help than they thought they needed. So that's why that's the busiest time for this area of law. So the type of Medicaid benefits that we help with is skilled nursing. So at the point where you need enough care to either be in skilled nursing or you are in skilled nursing, which is the part of the nursing home that looks like a hospital. So when you need that level of care, that's the type of Medicaid that we deal with. Federal government has a whole bunch of other Medicaid-related programs, but this is the one that we help people with. And one of the things that we want to make people realize is not to presume that you have too much for us to help you with Medicaid or too little to help you with Medicaid. We recently had somebody who went into a nursing home, and the nursing home did them a favor by filling out the Medicaid application form. And this lady had about $500 in her bank account. And so, and you can't have more than $2,000. So Medicaid, they thought, okay, this is going to be a slam dunk Medicaid application. There should be absolutely no problem with it. 4 months later, they get back the letter from Medicaid saying we're denying Medicaid. And the reason why they denied it is she had a burial policy that had cash value in it, meaning she could have pulled out money out of it. It was worth about $3,000, which is more than the $2,000. And the $2,000 for Medicaid is a bright line rule. So if on the first of the month you have more than $2,000, you're disqualified for that entire month period, and there's no way around it. So this poor family, what ends up happening is they get a bill from the nursing home. You owe us $24,000 because we haven't been paid and Medicaid's not going to pay us. And all she had was an extra $1,000. But under the Medicaid rules, there's no way to go back and get those 4 months. So you have to start over, we have to apply, and from here forward, once we started helping her, we were able to get her on Medicaid and she's fine. All we had to do was spend that $1,000. And she could spend it on anything, it doesn't even have to be the nursing home. So even if you think you're going to qualify for Medicaid or think somebody's broke enough that there's no way that they're not going to make it through the system, it's worth having an attorney involved. We've had lots of families where, especially with married couples, they have lots of rules against spousal impoverishment. They want to make sure that the spouse of somebody in a nursing home has enough money to live on. And so we can use a lot of those rules to make sure that the spouse does have enough to live on and is able to take care of themselves. Veterans benefits, the type we do is actually, it's an improved pension. It's based on the fact that you need help or with medical expenses. So the requirements are you have to have served in the military at least 90 days. 1 day has to be during a defined period of war. And for a lot of the wars, especially Vietnam, the dates are different than most people think they would be. I actually have clients who were drafted, served 2 years, and it's not during the defined period of war. I have clients who later voluntarily served, and it was, so it's worth checking the dates. You just look at your DD-214, see what the discharge dates are, make sure that you've got that information. If you have a family member that served in the military, if you can find their discharge papers, their DD-214, and you have the original, if you'll take it down to Denton County, they will record it for free and give you a certified copy of it. And that way, you've got it in case something happens. If you lose it, so you don't lose it, because it's a really important paper to get those benefits. But those veterans can get about $2,000 a month. It's where their income starts getting eaten up by medical expenses, tends to be when they qualify. It also qualifies for widows of veterans and spouses of veterans. But if somebody is a veteran, starts needing home health care, it's worth looking into and seeing. The way they calculate income, it's income minus medical expenses. So a lot of times, even somebody with high income, if they have high medical expenses, they may be able to qualify. Protecting stuff after it's theirs. Making sure your beneficiaries won't lose their legacy to divorce, creditors, and lawsuits. So the point where you leave money to somebody else, we're able to design a trust to wrap around it to protect them from the outside world. Now we can do this one of two ways. It kind of depends on the beneficiaries. If the beneficiaries are responsible with money and you have no doubt they would spend it well, then you can put them in charge of their own money. If you think that they're going to be vulnerable to the outside world, then we put somebody else in charge of the money and we figure out how to do this. Important stuff, how to communicate your values to the next generation. I have a lot of clients who are really concerned about the fact that they have spent their whole lifetime accumulating this money and what they're going to leave to their loved ones. And they don't really want it to be spent in a very, very short period of time. And so what they'll do is things like match the income that their beneficiaries receive. Because as I told you earlier, if people win the lottery, they're going to quit their job, their first thing. So if you leave somebody a substantial amount of money, they may decide they can quit their job. And so a lot of my clients are concerned and want to make sure that the people they leave money to aren't tempted to quit their job, especially if they leave it to them relatively young. Or I have a lot of clients that are also concerned about making sure that the people they leave money to get a college education. So that gets paid for. College education or trade school, that way that the money can be there for that. So whatever you value, whatever you want to pass down as information to the next generation, we can reward behavior. I just recently set one up where they wanted to make sure that their kids and grandkids remembered to give to charities, to care about other people. And so what they did is they took a pool of money and they actually put it in what they call a donor advised fund. And every year the family meets together and they vote on what charities to give the money to. So they get interest off the money every year. So that way they get their kids and their grandkids in the habit of giving away money and of caring about charities, and also teaching them how to evaluate, is it a good charity? Is it actually the charity you think you're giving money to? Because there's a lot of imposter charities that have names that are almost identical to the charities you're thinking of, but they're not quite right. So they help them figure out how to evaluate that. Or does 90% of the money they raise go to the salary of the guy who's running it? Those kind of things they want to make sure that they do. Other thing is, if you want anybody beyond you to remember anything you valued, any family stories, those kind of things, write those down so that they get that information. Retirement stuff, we're actually going to do a seminar on this. I believe it's in October. Retirement plans in particular, when they go to a non-spouse beneficiary, they can actually be stretched out over that beneficiary's lifetime. We can stick it inside of a trust, and we can make it where it's protected if they get divorced, if they get sued, or if they have creditor problems. And if we put it inside a trust wrapper, the trust wrapper does that protection, but we can also put restrictions on it. So if you wanted to make sure that your kids or your grandkids or your nieces and nephews or whoever you're leaving money to has money for retirement, because people under 50 are not going to have a pension. There's not going to be a company pension like a lot of people older have. So, and the other thing is people are not saving for retirement. Our statistic the other day, they said the average 50-year-old has $10,000 saved for retirement. How is somebody going to live on $10,000 when they retire? Now, maybe they're going to accelerate and start saving more, but probably not. So a lot of my clients say, wait a minute, if I do pass my retirement money down to the next generation, why not make it where it's a retirement fund for these people so that they have something on the back end? They have the ability to take care of that. Finding stuff and organizing stuff. You know where to look, but they won't. If you hide money anywhere, write it down somewhere. 2 reasons. You start losing capacity, you need to know where that money was. Or when you pass away, the family needs to know. Goodwill says that they get thousands of dollars a year in pockets of jackets, pages of books, because people hide money throughout the house. Now, I always tell people, not a note on the fridge, dear thief, this is where you need to look. It's got to be a little more subtle than that. But where do you hide things? Other thing is passwords. You need to give people the ability to get into all your online accounts. Be able to shut down your Facebook account, things like that. Second marriage stuff, how to protect your spouse and your kids. If you're in a second marriage and you don't have something in place, your spouse and your kids are going to end up co-owning everything. And even if they get along now, if you put money between them, a lot of times that causes really hard feelings. I had a lady come to me many years ago. Her husband had a tract of land prior to them getting married, just dirt, nothing on it. Shortly after they got married, they borrowed money and built a building on top of it. And she ran a business out of that building for the 25 years that they were married. He died suddenly. After mowing the lawn in 100-degree heat, came in, sat in a recliner, had a heart attack, and died. Under the law, her and those stepkids co-owned that building and that business. Probably not what he would have intended. He probably, if they'd come in and done a will, probably he would have left that business to her. But because there was nothing in writing, we ended up having to fight. We didn't get her more than what the law initially allows you to have. but it took a lot of fighting in order to get her, and she still didn't end up with all of it, she just ended up with a portion of it. So if you're in a second marriage, you need to think through that. The other thing a lot of clients don't think through, even in a first marriage, the way I've got mine set up, James and I have been married 29 years, I leave everything to him. He can spend it on anything he needs or wants. But when he dies, he has to leave it to our two boys. Because I don't like the idea of my boys getting disinherited. And I've seen too many situations where the spouse remarries, or picks a favorite kid, or some random charity that takes care of you the last 6 months of your life. That's who ends up with everything. I want my part to end up with my boys. Now, I have people all the time that'll come in, and we've been married over 50 years. There's no way either one of us is getting remarried. I had a client who was married 62 years. She died within 3 months he was remarried. About a year after that, he came in and he redid his will, and he left everything to the new wife, totally disinheriting his family. He has 4 wonderful kids, lots of grandkids, good people, but they're all grown and they don't need the money as much as the new wife. So it bothered me, at least my part I want to end up with my kids. Now if he wants to leave his part to the new wife, I'm fine with that. It's just, actually it really bothers me to think of a new wife, so never mind. I should be fine with that, but I'm not quite fine with that. So, but it's something to think about even in first marriages. Do you want to make sure what you're leaving behind makes it to the people you want it to go to, or are you okay with them leaving it to whoever they want? Now, about a third of my clients, when I ask that question, they're perfectly fine with their spouse leaving it to whoever they want to. They just want them to be happy after they're gone, and they're fine with that. A lot of what I'm going to talk through with you when I meet with you is exploring what you want. So if I tell you anything like that and you go, oh, I'm okay with it, or I don't want to restrict it that way, that's fine. We can design it for what we're doing. Sentimental stuff. Save your family for conflict or confusion over personal property. I've been giving this speech about 15 years. And when I first started, they actually said one of the biggest conflict areas of people was who gets the personal property. Nowadays, a lot of times the conflict is over who has to take the stuff or go through the stuff that mom or dad have accumulated over the years. But there's still probably 1 or 2 sentimental items that the kids associate with you that they're going to want to make sure, or they're going to argue over. I actually have a pocket knife that's on a chain that's attached to a watch, a pocket watch. And I realized the other day when I was giving one of these speeches, I think it's been about 4 years ago that I figured out I'd done this. I actually promised that same thing to both my boys. One of them collects pocket knives. The other one thought the watch was cool. And the way they asked me, because actually I don't care because I'm going to be gone, who ends up with it, but I set them up to being really mad at me, if you think about it, because I told them they both could have it, or mad at each other, because there's no way Mama would have promised that watch to you, because she knows I collect pocket knives. And then the other one says, but I do too. So that's, you got to think through it. I recommend you write it down, sign it and date it, and that way they have a record of it. If you change your mind and give that thing away to anybody, write it down. Because I can tell you lots of stories, probably legitimately people stole stuff, but then also people thought people stole stuff because it was gone at the time somebody died. So write it down. If there's any story behind it, write down that story. Do not write the story in cursive. They're not teaching cursive anymore. The younger generation is not going to know cursive. So they're not going to be able to read it. So, but write it down, because I hear a lot from daughters when mom dies. They'll say, Mom told me the story behind this pocket watch to the point I was sick of hearing it, but now that she's gone, I can't remember. So if you want a record of it, or you think the family would want to know, write it down. Till we meet again, keeping your plan current and up to date. Has it been over 3 years since you met with the attorney that drafted your plan? I meet with my clients every 3 years just to see what's going on in your family. And I'm amazed at the number of times that I meet with my clients that there's something big going on in your family that dramatically affects your plan, but you haven't thought of it yet. So for instance, I've actually had 3 or 4 people come in that have a son-in-law appointed executor that is no longer a son-in-law. And they just forgot they put him in there. They liked him back then, they don't like him now. Or they've got something like, there's a child who, one of my clients came in, they were telling me about the family, they said, oh, we're just coming to say hi, we'd like to come visit with you every 3 years. There's nothing going on different in our family, we're not going to make any changes. And so I start going through and asking them about the kids. Well, we get to Susan. Well, Susan has been in a car wreck, and she has a head injury, and she can't handle her own money. But her husband's paying all the bills and everything's taken care of. But he was leaving Susan about $100,000 outright. Probably not a good idea if she's not able to handle her own finances. So a lot of times it's exploring, making sure that what's going on in your family, we adjust the documents to. Now I meet people all the time when I ask them if they have a will or a trust, they'll go, oh yeah, we prepared it years ago, it was some guy in Dallas, I don't remember his name, we didn't really like him, and we haven't heard from him since. Well, probably your plan, there's some things that have adjusted over the years that need to adjust. And with my clients, I consider it a relationship. That's part of why I do these seminars. A lot of times I'll have clients come in just to refresh their memory or to think through their plan to make sure that they've got it in place the way they need to have it in place. The other thing is I charge everything on a flat fee, so the 3-year meeting doesn't cost anything. You call me and ask questions or email me, doesn't cost anything. And the reason for that is I want to make sure that if you have questions, you feel comfortable calling me and asking them instead of wondering what your plan says. I've had people move in from out of state, ask me to review their trust. I'll go over it with them, tell them what it has in it, and they'll be shocked at some of the terms. I've actually had 3 different people that have moved in from out of state that their plan literally said if husband or wife died, everything goes to the kids right now. This is a first marriage, so kids of that marriage, they're both those kids. And they didn't have enough money for half of everything they have to suddenly go to the kids. So I don't know if they had won the lottery and they've already blown through it, and that's why the plan was set up that way, or if for some reason the attorney misunderstood what they wanted to put together. But what they have in place and what they said they wanted are totally different. So that's one of the things, like I said, you tend to put it on the shelf, tend to forget about it. But if we can make sure that it's actually what you want and worded the way you want, it's going to be much better for the family. So does anybody have any questions?
Whenever, okay, say we were to pass and we've left it to the kids, okay, is there a charge then to the kids? Do you charge them to come in and do what you need to with them?
With the kids, what we do, when somebody's passed away, it's a client of mine, and the kids pass away, I do an initial meeting, which is usually an hour, hour and a half. And usually in that period of time, there isn't a charge because there's, for that hour, hour and a half. And usually in that period of time, if they have a trust, you have trust, I can easily explain to them what they need to do. So they easily step in. Every once in a while, I'll have a situation where the kids need more hand-holding. And if that's the case, then I try to do everything on flat fee. I try really hard not to charge anything hourly, so I would quote them a fee based on how much work I think it's gonna be. If you have a will in place and not a trust, there is a charge. We have to go through probate. Probate is a 2 or 3 month process, costs $3,000 to $5,000. So it's a much more expensive way to go. But with a trust, you should be able to transition it to the kids without any extra cost.
I got a question. If a person's like disabled or has serious ailment and has high expenses when they pass away, will that debt go to the spouse?
The debt, part of the debt, it depends. The part of the debt will go to the spouse, yes. It would not go to the kids or anybody else who inherits. So if you ever have an estate where the debt is higher than the assets that you would inherit, you can walk away. What the attorney, what the spouse would need to do is consult with an attorney. It has to do with whether the property was separate or community and how the debt was incurred, the medical debt was incurred. So there's some, and probably be worth consulting even with a bankruptcy attorney to make sure that we only pay the debts that you're required to pay.
You mentioned that, that are your kids responsible? Right now, mine haven't even made enough money to tip. That means they're struggling so.
Right.
So I don't know if they're spending most of what they have, just trying to, because I said, I told my husband, I said, we bought a house, and when we bought a house, the house note was $132. I said, now they got to buy a house, and the same, it's not even equivalent to that house, but even just the beginning, a starter home is costing them over $500 or $600 a month.
Right.
And so they're really just pushing out so much right now. I think if they had it, they would save it, but what I would like to know, you said that, but if you don't, right now, if I don't know, cause I'm an older mother, I started late. So I'm 60, my oldest son is 30.
Right.
So I'm really worried about trying to make sure that they're taken care of. But at this point, I'm not sure. So if we making these plans, I should look at somebody outside of my family that I think is responsible. I just wanna know who's that person?
So a lot of times what we can do is we can put somebody else, your question is who's that person, let me answer it. With the kids, cause you don't know yet, but they're for sure whether they're gonna be responsible. It would be worth putting somebody else in charge of their money until they hit some age, maybe 35 or 40.
Okay.
But some age out there so that way they have time to mature.
Yes, exactly.
And time to do that.
Settle
And, yeah. Some of my clients will appoint a family member that's responsible to be in charge of that money. Some of my clients will appoint a corporate trustee, like a bank or an Edward Jones, or, and the advantage to doing either a bank or an Edward Jones or lots of other companies, Franklin Templeton, an investment firm of some sort. The reason to do that is that way the money will be managed, so you're sure nobody's gonna lose it in the period of time they're managing it for the kids. They can also teach them how to manage money. We talk to them about how do you choose an investment, what do you do with it, what makes sense long term. Because a lot of times, especially like home ownership was one of the things you mentioned. For home ownership, they may not realize that if you take this amount of money and you buy the biggest house you can possibly buy, you're gonna have to pay taxes and insurance. And what if the roof needs to be replaced, or there's plumbing leak, or, and a lot of people will take everything they have and put it into a home, but then not realize the ongoing expenses. So if they have an outside person that kind of can teach them how to walk through that, that makes a big difference.
How do you? Sorry, you go.
Yeah.
Oh, thank you. My question is, say a loved one that you are an executive for, and something happens that's probably not in place prior to, and they become ill, and they have assets, but you want to protect them, and yet they don't have quite enough, but they have just, like you said, the 2,000 that you have to be spun down to. My question is, if those things aren't done timely prior to, and you're almost in that process, what's the best way to protect any other assets they have, so that they go to family or who that loved one would want, and they still need to have a Medicaid, kind of say nursing home bed or that kind of thing? How would that best work?
For Medicaid, there's two types of planning. There's the 5-year planning, which is you're asking about crisis, which is the second.
Right, all of a sudden you're
The 5-year planning is 5 years ahead of time. We can do a lot of planning, we can protect a lot of money. Crisis planning is gonna need care in the next 5 years. So either needs care right now this moment, or pretty positive that we're going to need care in a short period of time. Crisis planning, most of the time for a single person, we can create a trust to set aside about half of their money. And that's the part that's set aside, but then we can then buy them a private room, we can get them better care. I always get people focused on, let's take care of the person whose money was best we can. But even if you get them on Medicaid, you're gonna want to buy better care. You're gonna want more care. Now Medicaid right now, there's no distinction between a Medicaid bed in a nursing home and one that somebody private pays. You're gonna get the same level of care there. But it's one caregiver to 40 people. And if you need more care than that, if we set aside part of the money, then we can actually use the part we set aside to pay for more care or a private room or a lot more services. For a married couple, most of the time in crisis mode, so if they have a spouse at home that's still not in a nursing home, we can actually protect most of the money most of the time. Now, if you have a crazy amount of money, we don't even talk about it. But a lot of people, if you want to make sure the spouse has some money to live on, it makes a big difference if we do some of the Medicaid planning. So, and then, like I said, in November, I'm doing the seminar where I can talk a full hour and a half on it for you. And then,
If a person is interested in talking with your firm about setting up a trust, what are the steps to go about it? I mean, what preparation and information does a couple need to bring with them for an introductory meeting, or to assess what the cost is going to be and things like that?
the way I do things, or the way our firm does things, it's a $350 consultation fee. You come in and I get to know your family. So I get to know what we're putting together. Once I know what we're putting together, then I actually quote you. Usually I give you 3 choices. So based on the level of protection you want, whether you want to avoid probate or not, there's prices based on that. The information that we need before the meeting, I send out questionnaires, and my purpose in sending out the questionnaires, I'm not real picky on making sure that you fill them out fully. My main purpose in doing it is to give you a chance to gather information. So if you have out-of-state property, it makes a difference in how we set up the plan, or if you own a lot of companies, it makes a difference. Or, but it also allows you to gather names, addresses, phone numbers, and birth dates for the kids. Because I'm amazed, especially in this age of technology, the number of people that feel embarrassed if they don't know that off the top of their head. So if I have you fill it out ahead of time, you're a little more comfortable, you can look it up, make sure you've got it right before you come in, and then I have that information. The other thing is like just a listing of assets, because it is, a lot of times people will, over their lifetime, will maybe buy a lot in Florida that they're gonna put their RV on when they retire, but they bought it 40 years ago, and they've forgotten about it. But as you're going through the list, it reminds you that that's there, and we might need to do something with it. So the questionnaire we send out is just to give us an overview of what we're dealing with. Other thing is, I like to know a little bit on assets ahead of time. It just gives me an idea, because if you're leaving a small amount of money to people and you're wanting to put a whole bunch of protection around it, it may make sense to do something different, like maybe an annuity, or there's some other ways we can go. But I want to make sure we know what we're planning with, or what we're trying to protect when we put it together.
And I'm sorry, I didn't understand, if the first meeting, if there's a charge for it, if that's a.
It's a $350 consultation fee, and it goes, sorry, I didn't say this part. $350. $350. It goes towards whatever you do. So very rarely does somebody pay me that $350 and have that be just, they walk away. Most people that come in, it applies towards whatever you do. Even if I have occasionally somebody that all they need ends up needing is a warranty deed to protect the house, that $350 would go towards that, and would pay for that house, that deed for that.
Is there any kind of an average that you can say for a trust, for instance, that it costs for an average trust instead of that?
Right. The hard thing on average is I do another whole speech on this, but the whole speech, one of the things I try to get you guys to understand is it's not like a bag of sugar. So so a lot of times people think of it as, okay, I want a trust, I know for sure I want one, I just want to find the cheapest one out there. But really it depends on what bells and whistles you put on it. So what protection we put on for the kids, what protection we put on for the grandkids, whether we give it over a lifetime. The range is really wide. It's between 3 and about 11,000, depending on what we put in it, and whether we're protecting the retirement plans or not, is one of the pieces of the puzzle. Whether we're trying to protect for Medicaid down the road. So that's why it's easier if we actually talk about your situation and quote prices based on that, as compared to a broad range. I've also found that whenever I give a range, people anchor on one number or the other. And it's kind of interesting. It's like, and usually the person that needs the most expensive one is going to anchor on the lowest number.
What's that range you said?
Between
3 and 11. 3 and 11.
I anchored on the small.
You just follow, yeah. And the hard thing is, like, until I know what you need, because it may be a matter of I tell you that range, but then when you come in, there's another way we can plan. Like I think I just did one for a guy, where we figured out that his house we could take care of with a deed that transferred it on his death. We could take care of all of his accounts that way, and he's relatively close to the end of his life. And so anyway, so planning wise, we figured out how to do the plan that way. We didn't actually need the trust for him in that situation. So that's the other thing, is like, until I know your situation, I'm not sure I know where we're trying to land.
Okay, so are you saying that it's better to have a trust than a will?
Most of the time. The difference between a trust and a will is, with a will, when you die, we probate it. So we spend 2 or 3 months in court. You're going to spend your family's going to spend $3,000 to $5,000. A trust, we can actually, if you pass away, the people that take over just immediately take over the assets and you don't go to court. The other upside to a trust is, if you become incompetent, the people you want to have be in charge of your money get to be in charge of your money. And they don't have to go to court to do that. Because the other thing is, if you become incompetent, if you have any bad people in your life, those tend to be the ones that raise their hand and say, hey, I'd like to be in charge of her money. So we can keep that from happening by having a trust in place. But every once in a while, I'll have somebody that a will makes sense, and I do both. So it's really kind of an analysis of your situation and what you want to put together. Yes?
You made a statement.
This way. She's gotta have eye contact.
Okay. You made a statement saying that if you want someone to have something, to write it down, and, if you write it down, you take it to your lawyer, what do you say?
Yeah, what I'm talking about when I said a statement, I mean things like jewelry. So your earrings, who you want your earrings to go to, maybe paintings, household contents, things like that. You can write those down, sign them, and date them, and then it'll go to those people. Big things like cars or money, those need to be done in an actual will or trust and spelled out. But little things you can write down, sign, and date. And what I recommend is my clients actually send me a copy of it. Because I can tell you stories of those lists disappearing because whoever found it first didn't like what it said. So I get a copy that way. But the reason why we do it separate from the will or trust is so you can change your mind. Because as a granddaughter or grandson comes over, you may change your mind as to who gets what.
And you don't have to have anything notarized?
That one doesn't have to be notarized, but it's not as binding as putting it in your will. So if you had a family heirloom that's supposed to go to the oldest grandchild, I would put that in the will.
Yes, but is it best to get it notarized?
It is best to get it notarized so you can prove that you did it, yeah.
You did.
Yeah, if you think anybody's gonna have a conflict with it, it'd be good to get it notarized to prove you signed it. Yeah.
Does your firm manage trust funds?
We do not, but I know several banks. I have about 4 banks on the list that I recommend to my clients that do a really good job with trust.
Do you have any idea of the standard, is there a percentage or?
It tends to be a percentage, tends to be around 1%.
1%?
1% of the assets they manage, but most of them have minimums, so there's a minimum fee. But you can visit with, like I said, I've got 4 different trust officers that you can visit with, see which one you're most comfortable with. Definitely want to talk to them ahead of time. I actually had a client whose husband was incompetent. She was going in for surgery. She tried to call up Chase Bank to talk to the trust officer to let him know. And it took her 4 days to get a call back. And when she finally got a call back, they said, "Oh, we don't handle trusts under $5 million." And this lady didn't have $5 million. And so, if you're going to appoint a bank or a corporate trustee of any sort, make sure that you vet them. Make sure that they're comfortable with handling your things. There's one corporate trustee here in town that will not handle rental property at all. So if you have rental property, they won't even take your trust. So it's important to make sure they'll take the type of assets that you have and will handle things the way you want to have them handled. If you have a disabled beneficiary, which is not what, there's certain ones that'll handle special needs trust, there's others that don't like to handle special needs trust. I think there was a hand this way, but I don't know where, and then I'll go. Okay, maybe not. All right, go ahead.
I was just gonna
I'll come
ask
back to you.
if you appoint a trustee and then say something happens to them, you didn't even know it, what happens?
It goes to whoever you have next, and then the language in the trust should spell out how the next person is chosen. So most of the time, if there's nobody you've named, like if they're all gone, then the trust most likely would say whoever the beneficiaries of the trust gets to pick a trustee. And they may have certain criteria, like sometimes I'll put a corporate trustee in there and then I'll give the beneficiaries the choice. They can switch corporate trustees if they want, but they can't appoint their best friend. As far as that. Okay, this way.
Why would I get a corporate trustee? I mean, why would he want? I didn't understand why he asked.
Why would you want a corporate trustee?
Yeah.
Corporate trustee, the nice thing is you're gonna make sure the money is actually invested wisely. The other thing with a corporate trustee is if you've got one responsible kid and one irresponsible kid, if you put the responsible kid in charge, you're gonna make the irresponsible, it's gonna hurt their relationship. So occasionally you'll put a bank in so that way there's a kind of a mediator.
Okay. Well, you go ahead, sir. If you have a will and you have a number of beneficiaries because of the children, and a couple of the children are deceased now, what do you need to do?
If a couple of the children, they have kids,
Yes.
then it's up to you. You can either leave it to the kids that are still alive or you can add in the grandkids.
So it automatically goes to the children.
Right. Most of the time, wills are written that way, so if kids are alive when you write the will, then it would go down to the grandkids. But it's worth looking at. Because occasionally I'll have somebody say they just want it to go to surviving kids, not really fully thinking through if one died, how they feel about the kids.
Can you buy that book on Amazon?
You cannot. probably need to put it on Amazon, but I don't have it on there yet. Kindle edition thing, yeah.
That's all I have anymore.
Is Kindle? Yeah, I've not done it yet. I looked briefly into it and haven't gotten around to it. And they have it, when I looked at Amazon, you have a choice. You can give them a whole bunch of books and let them put it all over the country, and then they ship directly from that, or you can ship on demand. So anyway, I got caught up in which one I wanted to do and didn't decide.
So like what, Barnes and Noble?
Actually, I have them here, and then I have them on my website. Was what I have right now.
Can you skip a generation on a pass-through?
Yeah, you can. There's rules. If you leave more than $1 million that you're skipping a generation, there might be a tax. But that's the only problem with skipping a generation.
A will should be reviewed every 5 years.
I do it every 3, just to see
3 years.
see what's going on with your family.
Currently, we don't have a legal will, a trust, or whatever, lots of kids, so just didn't wanna go through all that process. I did type out something, I cannot remember, but I believe I got it certified, but I'm not positive. And the daughter that's supposed to take care of all the stuff, she knows where that's at. Would that be legal if something happened to us both simultaneously?
Right. The short answer is probably it would be legal depending on what it says. From other attorneys, I've heard that only 2 out of 10 self-made wills, so either through a program you find on the internet or through one you do on your own, actually work on the back end. I can tell you, I've had 8 so far, so my next one should work. I've had 8 so far that have not worked. I've had 8 that have been brought in after the person died, that there has been a disaster related to it because of the fact that they did it homemade. One of them, the guy was really mad at his kids. So he wrote a will and he said, I want to leave everything to my brother. But he didn't use those words. What he said is, I want to leave all my business property and all my personal property to my brother. All he owned was real estate. And in the law, personal property is not real estate. The real estate wasn't owned by the business. So the only thing he owned that could have passed under the will, the real property, didn't, because he didn't word it right. So we ended up in something called a determination of heirship, meaning we had to figure out who his nearest living relatives were, which is the kids he's mad at. The kids he's mad at ended up inheriting everything he owned, except for the contents of the house, because he worded it wrong. So, and I can tell you, I mean, all the 8 stories involve that. My most recent one, the lady wrote her own will, and it says, I leave everything to Joe. No, I leave to Joe blank. And there's a big blank, I mean like the big blank on the page. And then she signed it. Well, does that mean she left Joe everything? Or does that mean she left Joe nothing? But it didn't say what she was leaving Joe. So a lot of times it's more, if you had the legal knowledge, you might be able to fill it out correctly. Other part is, I almost guarantee if you meet with me, at least once in the conversation, you're gonna say, ooh, I hadn't thought about that. Because I'm gonna make you go past, like, okay, you're leaving everything to this person. If they're gone, where does it go next? If the trustees you've listed, if they're all older than you, if they're all gone, who do you wanna have do it next? And who do you wanna have pick if there's nobody there? So a lot of the things you're not gonna think through when you write it yourself. So it's not a good idea. I had a guy many, many years ago, they were going on a vacation. He was really scared the plane was gonna crash, so he wanted to write out something really fast. So I actually gave him some words to write out really fast, and he promised he'd come in and we'd get his will done. I think he came in about 15 years later, and we actually did end up doing his will officially and doing it correctly. But once you get that Band-Aid in place, once you've got it written out in your own handwriting, you're gonna feel comfortable that it's the way it needs to be. And the only way we're gonna know is when you're gone and we try to do something with it.
That's actually what I wrote it.
We're going on a trip. Yeah.
I've got a question, well, a certain situation, the husband had passed, they had one child, he had passed, he had remarried, the son had remarried for the second time, and he had 2 children with the first wife, but the husband passed, and she was living off of his will, so she went and had a will made of her own, because she wanted to make sure everything was in place. So we went to do the will, and, once she did pass, and she put her second daughter-in-law in charge of everything, but once she did pass, the grandchildren came into play because they said that she was living off of the husband's will and not her own, even though she had gone to do her own personal will.
Well, it kind of depends on the way things are worded. I'd have to look at the wills to know exactly, because really it depends on how the language is, whether he gave it to her outright or whether he gave it to her in trust. And then even if you get it, when you leave stuff in trust for a spouse, you can actually say they have to spend their own money first, and then they can spend the one that died's money, or you can say they can live out of either bucket of money. And so it kind of depends on that. I think we're at about, we're about a time. Thank you guys so much for coming.